Good morning, students. Today I'm discussing about the topic winding up of a company. Starting with the term meaning of winding up of a company. Winding up of a company is basically a process whereby its life is ended and its property administered for the benefits of its creators and members. This is a process of winding up all the of the business of the company, of the artificial existence of the company, artificial legal existence in the eyes of the court of law, having a separate legal entity concept. So company starts by legal formality and company ends by legal formality. So this is about the uh, company. Because company is an artificial legal person. A company formed, incorporated by fulfilling those all the procedures which is required for the incorporation of the company and which is required for the registration of the company to get a legal existence in the eyes of law. But in order to you want to liquidate the company, or to want to wind up the company, close the company, for that you have to comply with all the legal procedures involved in the winding up of the company to end the life of the company and to and its property and its assets of the company, its status of the company, its status of the company, and all its members are ceases to be a member of the company because company does not exist after the process of binding is completed. Then so that gives an ends to the life of the company, uh, but members not end to the life of its members, natural members of the company, the shareholders of the company, the directors of the company. In whatever capacity they are associated with the company, in the founders of the company, creators of the company, bankers of the company. But it is only an end to the life of the company, start by legal formalities, end by legal formalities. So after completion of all the legal formalities in respect of the winding of the company has to ceases to its business, and the member ceases to be a member of the company, shareholders of the company, because company does not exist in does not exist after its process of winding up is completed from the part of the company, from the part of the court of law. So, after its winding up, the artificial legal, because company is artificial person, so life of that artificial legal person is ended, and its property, but the assets of the company administered by the directors of the company or members of the company, uh, all has to be sailed off in order for the repayment of the dues if any on the company. So, the administrators who are responsible for the winding of the company, they are called as liquidator, and and he is appointed to take control of the company, collects all the dues from the assets from the debtors and all, and paid to the creditors of the company. Paid states all family disputes, any surplus among the members in accordance with their respective rights. Like equity shareholders have different rights over the dividend of the companies of the company. Preference shareholders have different rights on the surplus of the company. So that is a process. Winding up is as a process. Whereby the life of the company, the artificial legal life of the company is going to an end, and all its assets are sailed off, all its liabilities, you can say, assets are sale or dispose of, and all its liabilities are to be paid off to close the books of accounts of the company, to close the ledger accounts, books of accounts of the company, financial states of the company, all the financial statements of the company to be closed to complete the process of winding up of the company. And Administrators called a liquidator. An administrator called a liquidator is appointed, and he is responsible. He is responsible for the collection of all the dues, any due on the assets of the company, and he's responsible for the payment of all the liabilities associated with the company. And if any surplus remains left after realization of all debts and after payment of liabilities, if anything left, surplus is left, then that is distributed among the members as per the or in accordance with the right stated with that particular number of shares which he or she holds with the company, whether equity share by nature or preference shares by nature. That person has a right to receive the his or her share in the surplus of the company if any remains after payment of debts due to the company, and after realization of all the assets, whatever balance remains left, that must be distributed, shared among the members of the company. Then, as per Section 2, Subsection 94A of the Companies Act 2013, winding up means winding up under this Act or liquidation under the Insolvency and Bankruptcy Code 2016. This is as per Section 2, Subsection 94A of the Companies Act 2013, that defines the term winding up of a company. Winding up means under this Act or liquidation under the Insolvency and Bankruptcy Code 2016. That is a definition defined also in the under this particular act, Insolvency and Bankruptcy Code 2016. So winding up means winding up as per the terms and conditions, as per the procedure given in the Companies Act 2013 in this particular section, and company has to follow the procedures or guidelines as mentioned in that particular act, in particular section of the Companies Act, and as per the Insolvency Bankruptcy Code 2016, in respect of the winding up of the company. Winding up is means you give you close down your business, shut down your business activities. So for this, you have to inform to your creators of the company, directors of the company, shareholders of the company, members of the company, that we are going to dissolve, we are going to shut down, we are going to close our business entity. Because of these reasons, you have to conduct a meeting is very important if you want to close your business of the company and winding up a business of the company, because certain procedures involved. You have to appoint official liquidators for the purpose of selling of the assets of the company, registration of assets of the company, and payment of the liabilities of the company. For this, you need a person, administrator, and liquidator, who that person is responsible for taking charge of the collection of all the assets and payment of all the liabilities, whatever to do with the company. So it is a process. Winding up is a process, and when its life is in corporation life, companies enjoys company enter into contract, enter a transaction with third party. Third party can file suit on the company. Company can file suit on third party. Company can expand its business activity, diversify its business activity. That is not possible after winding up. So you have whatever you want to do, you wish to do for the company, for the future state of the company, for the future prospects of the company. That is what you have to do before winding up. So after winding up, you cannot enter into contract with third parties, because company is not in the register of companies at the ROC of the company. The company name is struck off from the register of the companies listed, noted is listed at the register of companies as per the Companies Act 2013. So it is a process. That is a procedure is involved. Certain you have to legal formalities is involved in relation to in respect of the winding up. That winding up is a process. In meaning is ing meaning is a process. The winding up is a process, and the person concerned, the officers of the company who are responsible for the winding up of the company, they must follow that process yeah, to officially close the business of the company with notice to every members and shareholders of the company. creators of the company, directors of the companies, makers of the company, that we are going to officially wound up with the explanation reasons why company is going to wound up, which what are the reasons behind your wound up. So that must be specifically mentioned in the minutes of in the notice of the meeting, and it must be discussed in the meeting, and should be noted on the minutes of the meeting to be submitted copy of the minutes to the ROC of the company. For the record purposes. So, the winding up, in the case of winding up, you have to appoint official liquidator, and that is a very responsible positions in the company, and that person is responsible for closing the books of accounts of the company, and for officially responsible for binding about all the process in the company, to inform in the newspaper as well. They now this company is wind up account is in the state, and officially have to inform the members of the company and others stakeholders of the company that from this interstate we are not going to functioning anymore, and we're closing down our business entities, business units from this particular date. Uh, so that is a this information, because public money is invested in the company, and we're responsible for utilization of public money. Public fund is invested in the form of shares, in the form of debentures in the company. So it is up to it is the duty of the company to inform to their shareholders, inform to the members that company is not going to function anymore from this particular date, and companies officially liquidate of its business affairs from this particular date. And that is a process involved, which is a procedures involved, as section 2, section 94A of the Companies Act 2013. Under this act or liquidation under the insolvency or the bankruptcy code 2016. Then at the end of the winding up of the company, will have no assets and liabilities, because you already wind up. So company have no assets, because company realized all the assets, whatever debt in the form of debtors, in the form of bills receivable, in the form of other current assets. So company realized all its assets and paid all its liabilities, and it will therefore be simply a formal step for it to be dissolved. So now, but that leads to closing of the business unit, with closing of the business enterprise company. So after your closing of your business enterprise officially, and it is in records at the register office of the company. So after your closing, company will have no assets, because company sell all its assets and paid all its liability, whatever due to the company in the form of borrowed capital is loan, preferential capital is there, debentures are there. So company liabilities, so company has to pay to income tax authorities also. Income tax return has to be filed. Income tax has to be paid by the company. There's so many formalities has to be compiled with by the company for the purpose of winding up of the company, and it will therefore be simply a formal step for it to be dissolved, and that is for its legal personality as a corporation to be brought to an end. Winding up of a company differs from insolvency of an individual, in as much as a company cannot be made insolvent under the insolvency law, and besides, even a solvent company may be found. So it is different from insolvency. Winding up does not mean that you are declared insolvent by the court of law, or you are declared bankrupt by the court of law. That doesn't mean that winding up is a case of insolvency. Maybe you are solvent, but you wish to discontinue your business activities. So that doesn't mean that you're insolvent. Maybe you're solvent, very much solvent, and you wish to discontinue your business activities. And for that, you have to comply with all the legal procedures involved in connection with the winding up of the company. And company cannot be made insolvent under the insolvency law, because it will wind company going to wind up. It does not mean that.
company, maybe companies are solvency positions in a good conditions, financial conditions, but company decides, the members of the company, the directors of the company, in the meetings or the meetings of the company decides to discontinue because these reasons are there. Not the reason is not maybe not being solvency, but some other reasons are there. So company can wound up its business activities. Even a solvent company may be wound up. So. So winding up is different from insolvency. Insolvency means you're not able to pay even a rupee, one paisa or rupee, whatever debts due to the company. Company not in a position to pay, and you're only able to pay only 1 rupees and 1 paisa and a rupee or 2 paisa and a rupee. That is your legal financial status. You're not able to pay your debts on time, whatever due to you on time, with interest on time. So that is it means that, and for the past 1 year, so in that case you may be declared insolvent by the court of law or bankrupt by the court of law. So even a solvent company may be wound up. So in the end of winding up a company, will have no assets or liabilities, and to therefore we simply formal step to be dissolved. That's the process when process is winding up. And after winding up, when it's to complete that steps, that is means company is going to dissolve its business after compilation of all the formalities in respect of the winding up of the company. And for its legal personality, because company is a legal person, company is artificial legal person, company is an incorporate body corporate, incorporation is very important for the company, for the private limited company as well as for the public limited company. So after incorporation, you have to obtain a certificate of convention. That is a process of incorporation formation. That is a process of giving birth to the company. So company starts by legal formalities and company ends brought to an end by legal formalities. That is corporation or company. Corporation company meaning is same, brought to an end by legal formalities. And winding up is different from insolvency positions of the company. Company may be solvent, but company wants to end because of another reasons which company have already discussed in the meetings of the company and submit a report in the minutes of the meeting. And reasons are very genuine to close the business unit and to discontinue business operation. But solvent company may be wound up. This is about the meaning of wind up. Then we come to the concept of wind up. Where this concept is coming from, the winding up concept. So, in the words of Pennington, winding up or liquidation is a process by which the management of a company appears is taken out its director's hands. So that is in the words, the definition given by Pennington is about the binding of or liquidation of the company, and that involves the process by which the management of the company affairs, that is the directors of the company, board directors of the company, whether independent by nature, dependent by nature, whether executive by nature, non-executive by nature, and it's taken out of its directors' hands. So, because after winding up directors, they are no more the directors of the company. They cannot enter into contract on behalf of the company. Company cannot act as a principal for the directors. Directors, they are acting as a trustee for the company. They act as an agent for the company and enter into contract with third parties and other parties. After closing, after winding up liquidation, directors will no longer be a director of the company, and it is taken from the director's hand because management is company is going to close, so management is going to close. It doesn't mean that the closing company doesn't mean like closing of company is going to end. Doesn't mean that the person who runs the company, directors who runs the company, they are going to end. It does not mean that because the separate legal entity concept is implied on the company. Company is different and its members are different. So winding up or liquidation is a process that involves it ceases to be after liquidation, after winding up the company and its directors ceases to be a director of the company after winding up. So you no more longer acting as director of the company because company is not in records, company is officially wind up. Company discontinued its operation, so you cannot act as a director of such companies, which is not in records, official records, officially closed by fulfilling official legal formalities. So its assets are realized by liquidator, official liquidator appointed by the company, or maybe appointed by the tribunals, registered company law tribunal. In the cases there are certain modes of winding up. And its debts and liabilities are discharged out of the proceeds of realizations of assets, surplus of any assets can be utilized for the purpose of payment of dues, of debts and liabilities of the company as shown on the liability sides or the balance sheet of the company. So, after realization of all the assets and if surplus, if any, on the assets of the company paid the liability from by from these realization of assets. From this amount, company pays of their liabilities towards the third party, towards their suppliers, vendors, bankers, etc., income tax authorities. Company now in a position to closing its books of accounts of the company, and for closing we have to get realization accounts and that amount, if any surplus is left, if any that transfer to capital account of the capital amount, and then from which given to the shareholders of the company if any surplus remains with the company after realization of assets and payment of liabilities, and any surplus left that is distributed among the members of the company in the form of number of shares they hold held by with the company. So this is in the words of Paddington, the definition, the concept of winding up or liquidation of the company is defined by Paddington this way. Uh, so winding up of a company can be initiated voluntarily by the company shareholders or by an order of the court. In the case of voluntary winding up, the shareholders pass a resolution to wind up the company and appoint a liquidator to oversee the process. So, in the case of a court ordered winding up, the court appoints a liquidator, and the process is governed by the rules set out in the Companies Act and other applicable laws. So, winding up of a company can be initiated voluntarily uh, by the company shareholders, or it may be by the order of the court. We can initiate this process of winding up. So, company can voluntary company can initiate this process by holding, conducting meetings of the shareholders of the company with the shareholders of the company, and issuing a notice to the effect that company is going to wind up and companies plans to going to wind up, wind up, and for that. Consent of every member of the company is very important to wind up the company. The consent resolution has to be passed in the meetings of the company to get a consent of shareholders and members of the company in respect to winding up the company. Because you are going to close your business operation, so without the consent of the members of the company, how can you close your business activity? Because public money is invested, members, shareholders' money is invested into the company. So without their consent, company cannot be closed, company cannot be dissolved or wind up. So it can be initiated voluntarily uh, by the company shareholders or by an order of the court. In the case of a voluntary winding up, the shareholders pass a resolution to wind up the company and appoint a liquidator to oversee the process. So, winding up of a company can be initiated voluntarily by the company shareholders or by an order of the court. In the case of voluntary winding up, the shareholders pass a resolution to wind up the company, and the shareholders appoint a liquidator to see the process involved in regard to the winding up of the company. So, resolution has to be passed in the meetings of the shareholders meeting respect of the voluntary winding up. And in the case of court ordered winding up, the court appoints a liquidator, official liquidator, to complete the process of winding up as per the Companies Act or any other act applicable laws applicable to the company in respect of the winding up of the company. So the court can order the winding up and the appointment of administrative liquidator is important to complete the process because they are the persons who know how to close the books of accounts of the company, how to discontinue the business operation of the company as per the act. So, the legal nuances of closing of the books of accounts of the company. After winding up, that is process involving winding up the closing of books of accounts, payment of dues and all liabilities of the company. And then whatever balance left that must be distributed among the shareholders of the company in the form of number of shares of contribution into the company, whether in the form of equity shares capital of the company or preferential capital of the company. So it can be initiated voluntarily by the company shareholders or by an order of the court. That is a case of voluntary binding up. So any agenda, any business item in respect to incorporation, in respect of dissolution, in respect to expansion, diversification, uh, ag- that must be discussed. That must be discussed and deliberated in the meetings of the company to officially close the business of the company without discussion, without deliberation. If you are planning to close the business of the company by yourself, itself, it is not possible. That because company is a association of persons, combination of persons who are combined together for the accomplishment of the common goal of the company, common objectives of the company. And if you are planning, one, two, three persons planning to dissolve the company, wind up the company, that is not possible. You have to notify this matter in the notice of the meeting at least 21 days before the meeting so that the shareholders and members of the company better prepare for the meeting in advance and make a homework for the meetings in advance in respect to discussion of the deliberation of this item in the meeting of the company. And that is a case of winding company without resolution, without consent is not possible, and you have to obtain a consent in the meetings of the company in order to discontinue your business operations. Then come to the genesis of winding up. Genesis, you can say, origin of winding up, elements of winding up. You can say from this, why this come, where this come from, the genesis. The genesis of winding up, the origin, you can say. So winding up is a process by which his company is dissolved. That is a process of a dissolution of the company, and its assets are liquidated. Assets are liquidated means assets are realized. Assets are has to be sold off in order to pay off its creditors of the company, or suppliers of the company, lenders of the company, and with interest amount, if any, due to them that has to be paid from this realization of assets, from whether from bills receivable of the company or debtors of the company or sale of closing stock of the company, unsold stock of the company. Whatever realization is there from the assets of the company by selling or disposing of assets of the company, furnitures of the company, furniture buildings of the company, land and buildings of the company, any other important undertakings of the company, you have to sell off to close the books of accounts of the company, and for that official liquidation and dissolution, you have to complete the process of winding up and dispute remaining assets or remaining amount among the shareholders of the company. The concept of winding up can be traced back to the early days of corporate law, when the purpose of incorporation was primarily to raise capital for large-scale projects such as building canals and railways. That is the concept of winding up. Can be traced back to the origin of winding up, early days of corporate law, when the purpose of incorporation was primarily to raise funds from the general public for to finance their large scale projects such as building of roads, bridges, dams, canals, railways. That is the purpose of incorporation of the company, to finance the major projects of the company. That is the concept of winding up. That is traced back to the early days of corporate law. So that is a very this is not a that is a this is not a very new word. This has been already used in the earlier days of corporate law, in the initial days of corporate laws, when it is but the purpose of registration of company, formation of company was to only to primarily majorly to raise a capital from the general public for to invest in the large scale projects of the company, such as building of canals and railways. This is the meaning of this line. What is a genesis? You understand genesis meaning this origin from where this word come from. This is what comes from the company laws, and the company law is not our law. We have used the company laws of other countries to make our law. Winding up is the process. That is the difference between winding up and resolution is so that is a difference. Winding up is different, resolution is different, but we are using this term is interchangeably, simultaneously we are using. But there's some difference between these two terms, which we discuss later on in this session. Uh, Over the period of time, the purpose of incorporation of the company or registration of the company uh, expanded to include a range of business activities and rules governing the winding of the companies become more complex because there are certain formalities involved in the formation of companies, certain formalities involved in the incorporation of a company and winding up of the company, and it becomes more complex. It becomes more complex because a company starts by legal formality, that is very legal, complicated procedures involved. You have to take a file to file channel is there, you have to complete all the files and you have to submit a copy of the files to the ROC of the company. That is a process is very complex. The same like that process of winding up is also very complex and company is governed by a complex set of rules and regulations uh, as per the Companies of 2013 or as per the Insolvency and Bankruptcy Code 2016. This is about the genesis of winding up of the company. Uh, Genesis is that is history is very back holidays or corporate laws which is enacted in the in India in the year 1986. Again, amendments in the Companies Act in the year 2008, 10, and then 13, 16. There are so many amendments in the years. Over the years, amendments are there, insertions are there, deletions are there from the Companies Act. That is, this is not a new terminology. It's already we already know this term. This is used in the company to close the company, to close the business of the company. And what this we need, need to use this concept of winding up of a company for the purpose of resolution of the company. Then come to the cases of winding up. There's so many cases involved in connection with the winding up of a company. We are concerned about India, we're discussing about India. In India, the winding up of companies has been the subject of a number of court cases over the years. And one such case is Madhusudan Godhan Das and Company versus Madhu Woolen Industries Private Limited. It's a case name of the two parties involved in this case. One is Madhusudan Godhan Das and another company, and another one is Madhu Woolen Industries Private Limited. And this case is dealt with the issue of whether a company could be wound up if it was unable to pay its debts on time. That is a case of winding over a company because company is not able to pay its debts on time. That is a case of insolvency of the company. That is a case of bankruptcy declared by the company. Company is not able to pay its debts on time. If any interest due on debts, company is not able to pay. Company does not have funds to pay its liabilities on time. That is a case of the winding of the company. Company does not have funds. Uh, does not have money to repayment of its liabilities, dues on time with interest. This is a case. This is a case. Madhusudan, Godan Das, and the company versus two parties involved in that case. Another one is Madhu Woolen Industries Private Limited, and the court held that the company could be wound up if it was unable to pay its debts, and this was a valid ground for winding up under the Companies Act. Then come to the cases of winding up. There's so many cases involved in respect of the winding up of the company. And the important case we are discussing today, the important cases, there are so many number of cases, large number of cases, you can say, that dealt with the winding up of the company. But today we are discussing all the important, the significant cases in relation to winding up of the company. And the important cases official liquidator, two parties involved in this case. One is official liquidator, another one is Dayanand and Sons Company, which deals with the issue of whether company assets could be sold off before it's wound down. So the court held that the liquidator could sell off a company assets before it was wound up, and as long as this was done in the best interest of the company and its creditors. So the court held that the liquidator could sell off company assets before officially wind up the company to pay off its liabilities, pay off its dues towards the third party. And this is by the order of the court. The official liquidator has to comply with all the legal formalities in connection with the sale of the assets of the company, realization of assets of the company, say by selling, to make a realization account. Uh, because all the assets have been realized, all the liabilities has been paid off before winding up of the company, and uh, and this was done. This was done in the best interest of the company and in the best interest of the creditors of the company. So, company by the order of the court has appointed official liquidator to process the formalities in respect of winding up procedures of the company in the interest of the large number of shareholders of the company, creditors of the company, members of the company, lenders of the company, or capital providers to the company, prospective investors of the company, and other stakeholders of the company. So, one of the most significant cases in this regard, that is another one, is Oriental Trading Company Limited. In this case, the court defined winding up as a process by which the life of a company is going to end and its properties administered for the benefits of its creditors and members of the company. This is a case law. This is a various case law in respect of winding up of a company, that is Oriental Trading Company Limited. And in this case, the court defined, again I repeat this line, in this case, the court defined the definitions of winding up that the process, it is a process through which, by which the company is officially going to end, officially going to discontinue or closing its operation, uh, and its business, whether in the form of subsidiary companies or affiliate companies are there. The company is officially going to wind up, and its property is administered and controlled by the official liquidators for the purpose of realization, payment of all the dues and liabilities of the company, whether in the form of borrowed capital of the company that consists of the venture capital of the company, or that consists of unsecured loans and secured loans and advances of the company. And for this purposes, we are using, the court orders the company to appoint official liquidator for the purpose to administer and to control the process of funding of the company for the in the interest of large number of shareholders of the company, investors of the company, prospective investors of the company, vendors of the company, income tax authorities are there, and other interested person, other interested stakeholders of the company. So that is a case of binding of the company. We are discussing today. We are discussing about the important cases of binding of the company, and official liquidator has to be appointed as per the requirement of the company by the court of law to complete the process of binding. Because company starts by legal formality, company gets its artificial legal existence by legal formality. So company must handle legal formalities by fulfilling all the legal procedures in respect of closing of the books of account of the company, closing of the business of the company, and discontinue its business activities from this by uh, fulfilling these legal formalities in respect of funding. Then there's another important case in respect of finding about a company, that is a Seth Mohanlal versus Grain Chamber Limited. The two parties involved in this case, one is Seth Mohanlal, another is Grain Chamber Limited, in which the court, the judgment of the court, the conclusion of the court held that the object of winding up is to ensure that the assets of the company are distributed truly, fairly among its creditors of the company, among its members of the company, and that liquidator has a duty to ensure that this is done in an orderly and efficient manner. So this is a very famous case law that deals with the case of binding of the company, and two parties. I've already mentioned two parties involved in this case. One is Seth Mohanlal, another one is Green Chamber Limited, in which the court handled the objectives of binding up is to ensure that assets of the company, or properties of the company are distributed fairly among its creditors and members, and the liquidator has to be appointed to ensure all the legal formalities are properly compiled in an effective, efficient manner by the persons concerned, official concerns who are responsible for the to complete the process of binding up the company. That is another important case in respect of binding up. That is Seth Mohanlal versus Grain Chamber Limited. So, without knowing case law, not able to understand what is winding up is all about, because winding up is the you give an end to someone life. So, if you're not following the process, legal process involved in ending of the life that is required, and the legal life of a company, uh, it should be for the betterment of the company, it should be for the betterment, for the interest of the larger shareholders of the company, to end anyone's life. So, without the consent of the members of the company cannot end the life of its company, cannot end its life on its own. No one can end its life of the company without the consent of other members of the company or the shareholders of the company. No one can, meaning is that no one can end it you, no one can destroy you, no one can damage you, close you without your consent and uh, without the consent of others and without your consent. So no one has a right to make you an end, make you a die. So after this, after completion of legal formalities in respect of wildlife, company is going to end, company is going to die afterwards, because company is not in, cannot function in legal way, lawful way, after its closing of books of accounts of the company and striking out the name of the company from the register of companies by the register of companies. Cases are there. Cases are there because it must be with the consent. Anything that is a very crucial matter to be discussed. That is a very important matter, serious matter to be discussed with the members of the company to close down the business of the company. So without the consent, if it is done and it is illegal, and it is unlawful, then it is not acceptable by the court of law, not enforceable in the court of law, because it is not with the consent. to make any person die, to make whether it is artificial by nature, that person is not natural, that person is not physically present in the court of law to speak for his right that I'm not going to discontinue, I do not wish to discontinue. But because some members they wish to discontinue my business operation, because of that company is going to discontinue. That has to be display, that has to be presented, that has to be justified in the court of law. If any appeal is filed for NCLT by any member of the company, then it is not, the winding up is not as per the consent. It is without the consent of the members of the company, and we are not ready to for this winding up. We are not ready for this closing of the company, closing of business of the company, because we wish to continue, but due to some members, pressurization from some members, we have to discontinue business operation because they are very much influential by nature. They are very much using their force and caution for discontinuing the business operation of the company for their personal benefits, personal interest, and personal wish. If that is a complaint is given by any member of the company, any shareholder of the company towards NCLT, that matter must be taken into consideration for the purpose of not to discontinue or to issue order to the company not to discontinue its operation till further order is given by the court of law in respect of discontinuation of business operations. So that is a very famous case now, Saint Mohanlal versus Green Chamber Limited. So, in summary, winding up is a legal process by which a company is dissolved and its assets are sold off to pay its debts and distribute remaining assets to the shareholders. The process may be initiated voluntarily or by the court, and it's simple, complex process that requires the involvement of a liquidator who is responsible for overseeing the winding up process. So, in nutshell, winding up is a legal process. This legal formality is involved. Has to be compiled by the company and the member concerned and the person concerned with the company. Officers of the company, those are responsible for the closing of books or accounts of the company and for responsible for the winding up of the company. Procedure has to be followed. And by after following the procedure, company is going to dissolve. All its assets are sold off in order to pay its liabilities on time, with interest on time, and distribute whatever remaining balance among the shareholders or members of the company. So, legal process is involved. That is not your personal things. That is a legal matter is involved. Public money is invested. Public fund is invested into the company. So, and that person, company is a legal person in the eyes of law, although it is artificial legal person in the eyes of law, can be presented in the court of law by having a good documentary evidence in the court of law. This person company is registered in the register of companies at the register office of the companies by the state. So we can enforce our case in the court of law. So process may be initiated voluntarily or by the court, or it is a complex process involved that requires the involvement of a liquidator who is responsible for overseeing the winding up process. Then come to the procedure for winding up. There are certain procedures involved for the winding up of the company. Certain steps you can say involved, stages involved in winding up of the company, the methods involved in winding up of the company. This follows procedures for winding up of the company as provided under Section 361 of the Companies Act 2013 and respect of procedures for how you close the methods by closing books of accounts of the company, the procedures involved for the winding up of the companies under Section 361 of the Companies Act 2013. The proceedings for liquidations are carried out by official liquidator appointed by the central government. The summary procedures provides for the methods for winding up, other than winding up in situations of an inability to pay debts. So thus the winding up ultimately leads to the dissolution of the company. And in between winding up and dissolution, the legal entity of the company remains and can be sued and tribunal of law, that is National Communal Tribunal, or you can say NCLT, National Communal Appellate Tribunal. So winding up leads to the dissolution of the company, and ceases to be a legal entity in the eyes of law, in the court of law. And in winding up and dissolution, the legal entity of companies remains. It can be sued in tribunal of law. So after completion of all legal formalities in respect to winding up, the company is going to dissolve. After dissolution, after winding up, company cannot be sued in the court of law. But before winding up, it can be sued in the court of law. That is a tribunal. Tribunal is meaning that National Company Law Tribunal. So it can be sued in a tribunal of law. So winding up ultimately deals with the dissolution of the company. And it means winding up and dissolution is the two different words. That is the two different words. Winding up is different, dissolution is different. A legal entity of the company remains. It can be sued. Company can be sued. Third party can sue the company because it is registered. It is not officially closed, but it is in the process of winding up. So till it is winding up process is completed, the company can be a legal entity in the eyes of law, but not after winding up. So winding up does not necessarily means that the company is insolvent. A perfectly solvent company may wind up with the approval of the members in general meetings of the company. Then come to the procedure for winding up. Winding up a company is serious matter and that should be approached with caution and careful consideration. It is crucial to seek professional guidance and advice to ensure that all legal requirements are met and the process is carried out smoothly and efficiently. So, winding up of a company is a serious matter. This is a very crucial, important matter, significant matter to be discussed with the proper diligent manner, proper caution manner, after giving due considerations, grateful considerations to all the parameters which is required, to all the sections to be complied with, which is required as per the Companies Act 2013 in respect to winding up of the company. So it is a crucial to seek professional guidance and advice to ensure that all legal requirements are properly met with, properly complied with by the company, and the process should be carried out as efficiently, effectively, for the purpose of closing the books of accounts of the company. So, because you that is after closing a books accounts of the company, officially the company cannot enter into business transaction after your winding up. So before winding up, you can enter into transaction, but not after winding, because that company is not in records in at the register office of the company. It is officially closed company, officially dissolved company. So. So you have to run your business in effectively manner. You have to ensure that all the legal requirements are properly compiled with, properly met with. So over the period of time, the purpose of incorporation expanded to include a range of business activities. Uh, the reasons we have to mention the purpose of why we are incorporated as a publicly limited company, as private limited company, and reasons for expansion to include a range of activities and tools currently demanding a corporate companies will become uh, more complex. Uh, more complex. The purpose of incorporation expanded to include a range of business activities you have to include. And the rules also mentioned in the incorporation in respect to the vending companies become more complex because we have so many number of companies and big companies and subsidiary companies. The process involved is very complicated, difficult processes involved in respect of the funding of the companies. If the companies wishes to expand its business activities by incorporation, uh, and their company has so many businesses, it is difficult to wind up. You have to close all your business accounts, all your affiliate companies accounts, all your subsidiary companies accounts, holding companies accounts, for the purpose of properly winding up the affairs of the company officially. So today, the process of winding up of a company is covered by a complex set of laws and regulations, including the Companies Act 2013. Then come to the meaning of dissolution. Dissolution is already defined in earlier um, sections of this today class. Dissolution is different from winding up. So, the meaning of dissolution. So meaning of dissolution is when company is set to be dissolved, when it is ceases to exist, its business entity, uh, corporate entity, or ceases to act as a company, whether it is publicly limited by nature, private limited by nature, or one person company by nature, foreign company by nature, for government company by nature. When companies decided to dissolve its business activity, decided to conduct its business activities, um, that process, after completion of a process, that process involved is winding up, but the end result is dissolution. Now, after compilation of all the process in respect to winding up the company is set to be dissolved. Keys is to perform, keys is to function, keys is to exist, keys is to enter into transactions with third party, keys is to file suit against third party. Third party cannot file suit against the company because company not in records. So on dissolution, the company name shall be struck off by the registrar of the register of companies, and he shall also get this fact published in the gazettes of in the official gazettes to inform the general public that the company is going to dissolve, company is going to officially dissolve by fulfilling the formalities in respect of winding up the company. Thus, the dissolution puts an end to the existence of the company, and company is going to end its life and its term and its operation after issuing of this after issuing the certificate of dissolution of the company, certified after it is certified by the ROC of the company to dissolve the business of the company. And this puts an end to your life of the company as an artificial legal person in the eyes of law, having a separate legal entity concept, perpetual succession. Um, that is, members may come, members may go, company can has its own common security company. There are certain advantages, benefits available to a company that is not available after dissolution, after 1 year. That is not available to the company and not available to the members of the company, shareholders of the company. So company is going to dissolve its life and its life after the binding process completed. So that is a puts your life to an end. Of artificial legal existence and separate legal entity concept. Company is different. Dissolution of company does not mean a dissolution of its dissolution of company means that dissolution of the members, but dissolution of member does not mean that dissolution of the company. Again, I'm repeating this line. Again, I'm repeating this line for the students that dissolution of the company means dissolution of its members and discontinuation of its membership. Keys is to be a member after dissolution after one member. But dissolution of member, keys is to be a member of the company does not mean that company is dissolved, does not mean that company is vendor. Because members are different, company is different. Company starts with legal formality and by legal formality. Company has a separate legal entity concern. So company can be legally dissolved, but dissolution or retirement of the member, superannuation of the member, death of the member, disability of the member does not affect the uh, continuation of the company. Company is going to continue even its members retire, even its member is death of its member, even its member is disabled, even its member is born a superannuation. So in that case is dissolution of members, addition of member, or deletion of members, removal of members does not affect the positions of the company in respect of dissolution in respect of incorporation. But in the case of dissolution of company, automatically membership ceases to be a member of the company, ceases to be director of the company. After company is going to dissolve by fulfilling all the legal formalities in respect of binding of the company. That is the meaning of dissolution. Then come to the modes of dissolution. There are certain modes of dissolution of the company, and maybe what about it in the following phase? To transfer company entities to another under a scheme of reconstruction or amalgamation. In such a case, the transfer company will be dissolved by an order of the tribunal without being wound up. So dissolution of a company may be brought about in following ways. There are following ways for the dissolution of a company through transfer of company undertakings to another. So by this, under scheme of reconstruction, amalgamation, the company, original company is going to dissolve, going to wind up because the A and B becomes C, that is amalgamation of the company. Again, A becomes A2 and A becomes A3, that is reconstruction of the company. Uh, so true transfer of company undertakings under scheme of reconstruction and amalgamation. In such a case, the transfer company will be dissolved by an order of the tribunal without being wound up. So, through the winding up of the company, when assets of the companies are realized and applied towards the payment of its liabilities, the surplus, if any, is distributed to the members of the company in accordance with their rights. So, so in the case of amalgamation, in the case of reconstruction, in the case of mergers and all, acquisitions and all, when company transfers its undertaking to another company, in that case, the original company who transferred its undertaking, that company is going to end and A and B is going to close down its business operation to become C. So in that case, transfer company will dissolve by an order of the tribunal without being wound up. So you have to be dissolved your business activities by the order of the court without being wound up. That is a case of amalgamation of the company, reconstruction of the company, mergers and acquisitions are involved. In that particular case, the original company, the main company is going to discontinue its business operation. That is not wind up, that is a dissolution. You have to dissolve your company uh, by the order of the tribunal. And tribunal means national company law tribunal, or you can say national company law appellate tribunal being wind up. Wind up. So, through the winding up of the company, when assets of the company are realized and liabilities has been paid off by the company, if any balance remains in surplus or in losses, whatever balance remains, that is distributed among the members of the company uh, or shareholders of the company in accordance with their rights or the shares of the company. On that basis, whether equity right by nature or preference by nature, accordingly, uh, the surplus amount has been distributed among the members of the company.